This program is brought to you by the Practicing Law Institute, a nonprofit learning organization dedicated to keeping attorneys, professionals, and accountants at the forefront of knowledge and expertise.
Hello and welcome to the inSecurities podcast, keeping it fresh and staying wonky on the latest securities, regulatory, and enforcement developments with a practitioner's perspective on the stories you should be following. As always, I'm Chris Eckemoff, and I'm here with my co-host, Kurt Wolf.
It is good to see you here in the virtual recording studio, Chris. Although this time last week, I had the pleasure of seeing you in person in Washington, D.C. for one of our favorite annual events. Why don't you tell the listeners what I'm talking about?
Yeah, I mean, I'm glad that you said it was a pleasure, Kurt, because sometimes I know hanging out with accountants can add a little friction to everyone's life. But we're, of course, referencing the annual Securities Enforcement Forum in Washington, D.C. This is a unique one-day conference that brings together current and former senior SEC officials, securities enforcement and white-collar attorneys, in-house counsel and compliance executives, as well as other top professionals in the field.
And accountants. I mean,
That's
we got to get that in the list. You had like a whole section, a whole cheering section last week.
It's funny how you find a table to sit down. You get there early for breakfast because I'm a hungry guy. And then wouldn't you know it, the folks who gravitate towards your table also know that debits are on the left and credits are on the right. The Securities Enforcement Forum is held annually in Washington, D.C. since 2012. And Kurt, it has the honor or infamous knowledge of being the place where you and I first met back in back in 2016. This year's conference came at us last week, Wednesday, November 6th in Washington, D.C. Originally, back I think when we first got together, Kurt, there was a limited amount of seats available in person. Now, the conferences being offered by Securities Docket are fully available online. The number that I was told was around 800 folks were on the virtual sessions, as well as probably 150 people in the room. So definitely a conference that's a can't miss for those folks who care and think about the things we talk about here on inSecurities.
Yeah, absolutely. And I think one of the reasons that so many people show up in person, show up online. I mean, I know some folks reached out to me to figure out how they could get some tickets to watch remotely, because not everybody can make the trip to Washington, D.C. But one of the reasons is because they have such fantastic speakers. I think year after year, there are always, as you mentioned, a bunch of folks from the SEC who join the panels to give not the views of the commission, of course, but to sort of share the regulator's perspective on all things SEC enforcement. And then, of course, pretty much anybody that shows up on stage, and I'll say pretty much anybody to avoid you poking fun at me, but pretty much anybody who appears on stage is sort of like a who's who of the securities enforcement bar. And, of course, as we'll talk a little bit about later, it's always the hot topics you want to hear about. It's crypto and whistleblowers, financial and accounting fraud. This year, we talked a little bit about AI. In addition to like this time-honored topics, sort of litigation, investigation strategies, how to handle real corporate crises, insider trading, cybersecurity, right? So it's, again, year after year, they're hitting on some of the big topics that you would want to hear if you were going to an enforcement conference.
And Kurt, I'm glad you stole 40% of my jokes today by already referencing most speakers were there. Kurt, obviously, you served as a moderator for the panel discussion of AI, of artificial intelligence, which we'll get into, as well as taking over some of the MC duties for the second half of the day, which I think you did great, except for shouting to the peanut gallery of accountants at a certain point throughout the day. One other speaker of note, I believe this is the first, if not a very early discussion of the acting director of enforcement, Sanjay Wadhwa, speaking after, obviously, Gurbir Gawal left the commission in October. So great to get some of those insights we'll dive into. Kurt, we kind of want to do a rundown of all of our takeaways. Although I do regret in my notes, I did not get my usual list of who was the funniest SEC speakers disclaimer, because oftentimes they will read their rote kind of views of the commission or any of the commissioners. I forget who said it. I think it was the second or third panel had a great line. I will have to go back and watch the tape on that to grab that for future reference.
Yeah, absolutely. And I actually did see that. I think today they released the videos of the panel discussions on YouTube. So if you weren't able to attend, I'm sure you can find it out there. Again, good conference, worth tuning in. There were 8 panels, and we are not going to go through all of the panels today and give you our notes. We're gonna pick up a few of them that we thought were particularly interesting, and just sort of some of our key highlights or takeaways from those panels. But a quick rundown of the 8. There was a panel on cybersecurity rulemaking and enforcement, a panel on the impact of the election, a panel on enforcement priorities for asset managers, broker dealers, and private funds, my panel on AI and securities enforcement in that space, another panel on digital assets. Every year there is what they call a masterclass panel, which has to do with managing a true corporate crisis. And those are always some of the best speakers I find at the entire conference. There's another panel on financial reporting fraud. I think that is when I gave a shout out to the accountants, because that panel is always sneaky good. And there was an insider trading panel to almost round out the day. Last but not least, I like that they leave this one last, was the best practices panel, where some really notable practitioners talk about things like strategies for handling testimony, what the Wells process entails, or how maybe that changes, as sort of the staff changes or from year to year. They talk about things like managing settlement negotiations with the staff. So best practices is always a really good one. I know Bruce Carton, who organizes the conference, likes to do that one last to make sure everybody is still there at the end of the day and available for the cocktail hour, which is also a fun part of the day.
Yeah, I really enjoyed the rundown. And obviously, Kurt, you and I have practiced in this space for, I don't want to say how many decades yet, but it's more than one. I always feel like we learn little tidbits here and there. A lot of the things we'll talk about on the episode today are those little, tips and tricks and maybe reminders that we picked up along the way. But even for those of you who are in, deep in your practice, conferences like this, Securities Enforcement Forum and others, are a great way to kind of re-educate yourselves, remind yourself of some of the things that we deal with. It's taken me a while to fully understand, Kurt, a lot of the things you talk about, from the initial notification of an investigation to the Wells process to that original settlement negotiation through what may end up being a trial. And I think that really rung with me last week in terms of how the best practices really touched on all those issues.
Yeah, I completely agree. I mean, I remember the first couple of years I attended this conference, and certainly the first few years I attended PLI's SEC Speaks conference, I was feverishly jotting down every word that everyone said, or as close as I could get, because it was all kind of new and fresh to me. At this point, I've kind of got the nuts and bolts, I hope. Right. But it is those little tidbits you pick up along the way, or a little anecdote that someone tells that you think, that relates to a case that I worked on, or it's interesting that person has had the same experience too. And that's kind of what keeps me going back year after year, is those little practice points, which are just really helpful. So again, I think everybody knows by now that we love this conference, but it was great again this year. So Chris, why don't we talk a little bit about several of the panels that we thought were particularly good or particularly interesting or timely this year, and what better panel to start with than
timely.
Right, exactly. The panel that was called The Day After, the Impact of the Election on SEC Enforcement. And as it turned out, it was more like the day of, because the election wasn't called until the wee hours of the morning on November 6th. And just a few hours later, we all found ourselves in a conference room for the Securities Enforcement Forum. Another fantastic panel, Anita Bandy from Skadden. She was an associate director at the SEC for a long time. Bill McLucas of Wilmer, who of course was a director of enforcement. I think the longest serving director of enforcement ever at the SEC. Juan Magone of Stone Turn. He was a former assistant chief accountant in the office of the chief accountant. Nader Salehi from Kirkland and Ellis, another SEC enforcement alum. Bill White from Allen and Overy, a very good friend and mentor of mine, who was a former branch chief and senior trial counsel at the SEC. So a really good panel of folks who had all been there, and not all just in the same office, but kind of folks who had been spread throughout the SEC, throughout some of the regional offices, who were able to give a perspective on how something like a change of administration changes or is likely to change the way that people do things. Now, you might expect this panel started at 9:15 in the morning. A lot of folks had a late night the night before. Some folks may have had some cocktails, either celebrating or drinking away their sorrows.
Right.
With that said, it was packed. I think it was the busiest panel of the entire day. Everybody came in early, filled up their coffee, got in their seats. And I think it was because it just was so fresh. I mean, as I said, literally hours before the election had been called for President Trump. I talked to a couple of panelists throughout the day who said they actually had two sets of talking points prepared. One was sort of for a Harris-Walz administration, and another was for a Trump-Vance administration. And one of those sets of talking points got left on the bedside table.
Right.
Interestingly, most of the folks, I think, were expecting to come in and have to do a panel discussion along the lines of, well, we're going to have to wait and see because we don't know what's happened in Georgia or Pennsylvania or wherever yet. But it was interesting to see them all kind of adjust to the reality that we knew exactly what was going to happen, at least in terms of which way this race was going to go. I have to say, kudos to the panel. The tone was very moderate, I would say. I mean, it was not sky is falling. It was not, oh my goodness, like we're never going to see SEC enforcement actions again, or at least not for the next 4 years. It was a much more calm and reassuring tone. A few things that I think everyone agreed on. One is just that while we can start to think about what this transition will mean and what's going to happen in the next administration, the reality is Chair Gensler is going to remain in his chair for the next couple of months in all likelihood. Now, he could leave any time, of course, but I think the expectation among the panelists was that he's going to hang around for a while, in part because I think the view is that he feels like he has some unfinished business. And whether that's, getting a couple rulemakings completed and voted on and on the books, or whether that's, things that he wants to do from an enforcement perspective, I just don't think the sense is that he's done quite yet. So much of the same, I think, for the next couple of months. And if anything, I could imagine a world where the pace of enforcement ratchets up a little bit if they're trying to get some things done before a new administration comes in that maybe doesn't have the appetite for the types of cases that they're bringing, or those are no longer programmatic priorities for the Division of Enforcement. Another thing that I think everyone agreed on is that Hester Peirce, in all likelihood, will become the acting chair, certainly after President Trump is inaugurated in January, potentially sooner than that. Although, if Chair Gensler steps down before January 20, we'll probably get one of the other Democratic commissioners to step in for some little gap there that won't really leave enough time to do much. But so I think Commissioner Peirce is likely to become the next sort of long-term acting chair until a permanent replacement is named. And I think most folks would expect that to happen early summer, right? I think it's the earliest I recall seeing it in a change of administration is like the first week of May, something like that. And it can go into July. So somewhere in that period. All right. So these are just sort of like high level things I think folks agreed on. Another thing that maybe will surprise listeners is that I don't think folks expect immediate changes in terms of what the enforcement division is doing, right? And Bill McLucas actually noted that when Ronald Reagan took office for the first time, long ago, he had also been someone who campaigned on and came in with a lot of promises about paring back the size of the administrative state, or the things that some of the administrative agencies were going to do, avoiding overreach, things like that. And it didn't exactly happen in the way that President Reagan imagined, or the things that he said on the campaign trail. And in fact, at least with respect to what happened at the SEC. All right. So whatever happened anywhere else, we're not talking about that now, but at least with respect to what happened at the SEC, you kind of ushered in an era where there was more enforcement. I'm not saying that's going to happen here. I don't think the panelists were suggesting that, but I do recall distinctly the last time we were looking at a Trump administration, there was a lot of chatter about how SEC enforcement was likely to fall off a cliff. And people thought, based on some comments that, former chair Jay Clayton had made, or some things that he had written, that he would not be a particularly pro-enforcement chair. None of that happened, right? We continued to see the number of enforcement actions tick up. We continued to see the amount of penalties mostly tick up. And so I just don't think that, my view is I don't think anyone should draw conclusions. I think that's pretty consistent with what we heard from the panel. So really probably no major immediate changes in terms of how busy they're going to be. Now, look, the first year of an administration, the number of enforcement actions typically slows down a little bit. I think that's normal. It doesn't matter if you're going from, D to R or R to D. That just kind of is what happens. I will say the one area where I think everyone agreed that there is likely to be a sea change, and this actually came up on a number of panels, and that is digital assets, crypto. And everybody seems to think that in the next administration, which promises to be a little more crypto friendly, we will see probably less crypto enforcement or crypto related enforcement that is different in nature, right? Not necessarily focusing on things like alleged registration violations, right? Certainly not without giving folks an actual path to come in and register. So that was the one area where everyone said, listen, if there are going to be big changes in the next administration from enforcement that we can all agree on, like put your money on it, it's going to have to do with crypto. So I think those are, just checking my notes here, those are all of my big takeaways from the day after panel. But I don't know, Chris, if you picked up on anything else.
I thought it was interesting. There should have almost been another chair that was left open on the panel. And you've talked to this already, Kurt. I feel like everyone was responding to the statements that have been made from the Trump campaign, generally, as you mentioned, the administrative state or regulation of specific industries, as well as kind of what could be termed a pro-business focus for them. So to your point, right, it was not all doom and gloom from an enforcement activity perspective. I wrote down two great quotes from some of the panelists. The first, as always, a quotable source, Bill McLucas. When asked about how things will change with the new administration, he said, quote, "Bad guys and fraudsters aren't going to go away." I think that speaks to what Anita Bandy talked about in terms of, looking at those types of cases that will always have bipartisan support. Things around consumer investor protection, insider trading issues, as well as kind of those classic Ponzi schemes or failed investment vehicles. Those will always be a focus of the commission. And then Nader Salehi brought up another point I thought was interesting as they were talking about how the next administration might regulate and enforce. He said that no chair or no enforcement director wants to oversee a period of weaker enforcement. Right, their job is to continue to push that tripartite mission of the commission forward. So both of those comments really stuck with me about ways we might, kind of hedge a little bit in terms of some of the messaging we've received outside of that. One thing, Kurt, you didn't touch on that's obviously close to my heart is the recent, and I say recent meaning the past maybe decade or so, focus on internal controls enforcement actions. And one of the discussions that the panel brought up was that as that changed from what might be termed novel enforcement theories or stretch cases that the commission might consider bringing, the panel felt that those standalone internal control cases that point to a lack of internal control but don't have an underlying securities violation or financial reporting violation also charged at the same time, those might be another area of less regulation. If there is a financial reporting issue and internal controls didn't catch it, they felt that case would probably still be brought. But if you don't have that bright line violation of accounting standards or some other securities violation alongside the internal controls issue, you probably won't see those internal controls medals brought standalone, which I thought was an interesting point about where are we drawing that line on novel legal theories and kind of standard securities violations.
Yeah, it's a really good point. I'm glad you brought it up. I mean, I'm sure if our friend and my colleague Dabney O'Riordan was on here, she would talk to us about some of the cases against investment advisors where there's no investor harm, right? You see these enforcement actions, certainly in this administration and over the last 18 months or 2 years, where they're bringing a case that does feel like some kind of internal controls case or a books and records case. And it's they're footfalls, in some cases, they're kind of ticky-tacky cases. And the question is, like, who got hurt here, right? Do we need to really levy some major civil monetary penalty against these firms when you're not seeing any disgorgement, right? It's not to say that firms should just get off the hook. If they've broken a rule, they've broken a rule. But I think there has been an increase in those style of cases and in the monetary penalties that are going along with them. So I would agree with the panel on that one, and I think it's a really good note. All right. Let's talk for a minute about the keynote, which you mentioned earlier was delivered by Sanjay Wadhwa, who is the acting director of the Division of Enforcement. He spoke for, I don't know, would you say maybe 10 minutes with some prepared remarks, and then sat down for a Q&A or a fireside chat with Stephanie Avakian, who's at Wilmer and is a former director and former guest here on the show. Go back and listen. I thought the Q&A with Stephanie, frankly, was more interesting than the prepared remarks. But I do want to focus on the prepared remarks for just a couple of minutes, because there were some things to tease out that I think folks will be interested in. The first is, and of course, they always hate it when we talk about the numbers, but I'm going to talk about the numbers. Sanjay did, I think, start to lay the groundwork for a less than impressive SEC enforcement annual report for fiscal year 24. He said that they would not be releasing their numbers until later this month, and he wasn't going to say anything about the numbers in particular, but he said they would reflect another productive year. He later said, I know the numbers are going to get a lot of attention, but I think you should think about the cumulative impact of those cases. All of which leads me to believe that folks are going to see the number and go, right. Yeah, that's a little light. And he's trying already, I think, to reorient folks to think about the substance of the cases, or, the impact that they made, whether that's investment protection or investor protection, or, returning funds to harmed investors, things like that. So with that preamble, he went on to talk about 3 particular topics that he thought would be of interest to the folks in attendance that day, and that he thought were sort of reflective of the work that the staff has done over the last year. And so they were the off-channel communications cases, whistleblower protection cases, and cases in which the commission recognized and credited parties' cooperation with the division's investigations. Off-channel communications cases, I think, have been written and talked about almost to death. These are the sort of texting cases, the WhatsApp cases, where the SEC has found that evidently a large number of financial services firms, investment advisors, and broker-dealers did not have policies and procedures, or did not enforce policies and procedures that would cause people to retain things like WhatsApp messages with their clients. They've resulted in some pretty big numbers, right? So he reeled them off for us. In fiscal year 2024, the commission brought record-keeping cases resulting in over $600 million in civil penalties against more than 70 firms, including the commission's first cases charging record-keeping violations against municipal advisors. He also noted that this initiative dates back to December 2021. And that in that time, right, so 2021 to present, more than 100 firms have been charged. They've paid more than $2 billion
with a B
in penalties. And this part I think is interesting, and I think it's actually often missed in this dialogue. I will say many of the firms, in fact, I think all of the firms, admitted that their conduct violated the record-keeping requirements. Right. It still is a pretty rare case for SEC enforcement that the defendant in that case is required to admit the violation. But in these cases, they were. So if for no other reason, just in terms of the resources it must have chewed up on the staff, the number of cases that they've brought, the amount of penalties that resulted from those cases, it's always worth mentioning. So that was his first point. His second point had to do with whistleblower protection cases. And there was a wave of them right at the end of the fiscal year. I think in the very first one, which announced a handful of the cases, it was revealed that the staff had done a sweep relating to those cases. So these are all the 21 F-17 cases, which basically charge an entity for taking steps that did in fact or could impede a whistleblower from going to the SEC. Usually that happens in the form of some kind of NDA or a separation agreement, or sometimes in an employment agreement that says you may not report suspected violations of the federal securities laws to the SEC. A lot of times I think that to the extent that language still exists in different types of agreements, it's sort of artifacts that didn't get cleaned up along the way. I think companies, regulated entities broadly are doing a much better job of this, but they're still out there. And so this little sweep was another way for the SEC to remind folks, hey, you can't do that. And if after all this time, right, the whistleblower rules have been in effect for 12 years, I think if you haven't gotten it right yet, maybe take a peek, have a little look-see. Sure. The last point that he raised in his prepared remarks had to do with cases in which the commission recognized and credited parties' cooperation with the division's investigations. And I thought this was interesting because there's always this debate about what constitutes cooperation, for what types of activity, would an entity receive so-called cooperation credit, and how far do you have to go to get no charge or a lesser charge or less, stringent sanctions, right, in an SEC enforcement case. And so what he was saying is there have actually been a number of cases this year. And he mentioned a few of them, but there are even more in the footnotes if you want to go pull from the SEC's website, Sanjay's remarks. There are even more in the footnotes where if you open up, whether it's a litigation release or a press release or an administrative proceeding, a C&D order, there is some detail in there about what the companies did to earn some kind of credit. And I think it's always helpful when the SEC does that. I wish that they were a little bit more, I don't know, I wish that they said it a little bit louder, right? So everyone in the back can hear you, right? Like you should read this. Because if you remember way back, there was this Ralph Lauren case. It's probably like 12 or 14 years ago. That was a big deal at the time because they put a big, chunky couple of paragraphs in the release that explained all the things that Ralph Lauren did to earn some cooperation credit. They haven't been quite as noisy about it, but there are nevertheless a few cases that are worth reading. You can find them in the footnotes of Sanjay's speech, and you can kind of piece those things together to start to figure out maybe what cooperation has looked like over the last year. If we think back to the first panel, don't know if that's going to mean anything in the next administration.
Right.
But worth thinking about nonetheless. So anyway, those are my thoughts on the prepared remarks. I don't know if you jotted down any notes or good quotes from the chat with Stephanie.
Kurt, obviously we had Stephanie on the podcast. I've always seen her as a well-meaning and a nice colleague to share a discussion with. I was nervous, right, knowing that former director of enforcement, Stephanie Avakian, would be grilling the acting director, Sanjay Wadhwa, in what was termed a fireside chat. But I think she kept it well-mannered, as well as getting some good information out of the acting director. One thing I wanted to note, Kurt, is you talked about self-reporting. I don't remember if this came up in the discussion with the fireside chat or not. But one of the things I noted was that there was a discussion of if the self-reporting benefit outweighs or is consistent with or is understood alongside a lack of self-reporting punishment. That to me was an interesting idea when we think about, how acting director Wadhwa would consider that kind of cooperation credit. If you're self-reporting, do you get enough that is good for you along the way? Or are you in a position where you're kind of tiptoeing around an issue and the fact that you didn't self-report or you didn't cooperate fully actually creates a bigger hole for you to dig yourself out of? I think that led to an interesting discussion on a couple of the panels as we went forward.
I mean, I think it's always a very difficult analysis and a difficult discussion with clients when you're even thinking about a self-report is sort of, what's the benefit here? Is it tangible? They'll say, can you show us cases or can you tell me when this has worked before? Mm-hmm. What do you think on a percentage basis this is going to do? Those kinds of questions. And it remains very difficult, I think, to quantify. It's mostly sort of anecdotal or based on our own personal experience. That's why I think, whenever someone like the acting director of enforcement can, release remarks that have footnotes that say, look at these cases, it's helpful because I can talk about that with clients and say, well, look, in every one of these cases, they self-reported, right? Maybe that suggests that it's worth at least considering. But certainly the self-report isn't enough. If what ultimately you want is a declination, you're going to have to do, the self-report plus some pretty serious cooperation.
Amen. I know, Kurt, we've got a couple of more panels we want to touch on. We can do them a little bit rapid fire here. My favorite part about the accounting panel might just be the title, Minding Your K's and Q's. Nothing will be punnier than that in the future of securities enforcement panels, featuring Jason Flemons, a senior managing director at Ankara, a former deputy chief accountant at the Division of Enforcement, Mark Cave, who currently is the associate director at the SEC, Jennifer Leet from Cravath, an SEC enforcement alum, and another former guest of the inSecurities podcast, John Tuttle of Debevoise, and Sarah Walters of Ropes and Gray. She had served as the chief of the Economic Crimes Unit in the U.S. Attorney's Office in Boston. So a little bit outside officially the SEC, but a little bit more towards that financial crimes focus. A couple of things I took away from the accounting panel, Kurt, were the continued consideration of those classic accounting fraud cases, right? Again, there might have been another chair on the panel dais up there to show kind of those deregulatory comments that a lot of folks were speaking to in the post-election world. Their focus was really on the cases that are really about fabricated revenue or timing issues or some of the classic kind of accounting manipulation cases, if you will. They will continue to be investigated and to be subject to enforcement actions. One of the interesting things I thought was brought up on this panel was about kind of those technical issues as they're brought to the SEC in some of those Wells process responses or those settlement negotiations. And one of the comments was around speaking to generally accepted accounting principles or GAAP in a way that the SEC staff will hear, and being able to describe those elements, not just kind of in their rote, almost dusty technical way, but really talking about the impact of the decision-making around when generally accepted accounting principles may be applied in a reasonable manner and when they may not. I thought that was a very good kind of fulcrum on which to consider future enforcement actions in the accounting space to turn, is that, of course, those highline cases, those what we see in hindsight as obvious manipulations of the financial information will continue to come. Defendants or those subject to SEC enforcement actions should continue to consider how they're describing the choices they made. And reasonable accountants can differ on treatments under GAAP. Being able to present that information, in a good faith argument and a good faith presentation, I think is something I took away from that panel.
Yeah, it's an interesting point, and no doubt one that gets overlooked because I think you tend to talk about accounting in a certain way that feels kind of formulaic. And I think it's a good reminder that you can step back from that and tell a story, right? Because otherwise, if you were in there to talk about your widget manufacturer and the staff doesn't understand how to make widgets, but you just kind of assume they do, you're going to be a less persuasive advocate.
Right.
And I think the same is true when you're talking about, GAAP accounting or any accounting analysis for that matter. Like, wait, hold on a second. Let's try to do this in, sort of common man speak, like let's make sure everybody here gets what we're talking about. I think it's a really good note, I thought it was interesting. Obviously, we're going to talk about materiality a lot when we're on a financial reporting point, right? But there was a topic that came up on a couple of panels, and it has to do with reporting cybersecurity incidents or suspected cybersecurity incidents. And there was this notion of, how should you do that, especially when it's very early and you're not sure how big it is or how much of a problem it is. Is it material? Is it not? And there's been some guidance about whether you should disclose a cyber incident using a Form 8K item other than item 105, which I understand is where you're supposed to put material cybersecurity incidents. Like, should you throw it under something called item 801, which is other events? And like the issues that can come from what you decide one way or the other, right? You sort of you're almost damned if you do and damned if you don't. If you put it under 105, you've just told the world it's material. If you put it under 801, are you telling the world it's not material? Yep. So there were a couple discussions about this topic during the day that I thought were fascinating. And I thought maybe your ears pricked up as well.
I know for me, I've got that little voice in the back of my head of, I don't know anyone who knows kind of the stipulations and disclosures from a theoretical perspective better than him. But those are the tough choices, right? Like I said, reasonable accountants can differ in their opinion of how to treat some of these items. The cybersecurity discussion has been one that's been ongoing since I think 2018, when the original kind of merging of cybersecurity disclosures and financial reporting came together. It's always going to be a facts and circumstances issue. And I think having a defensible argument for the reasoning behind where that is disclosed is always going to be a best practice, even if questioned by the commission.
Absolutely. All right. We have time for one more.
Kurt, we have to. This was your, and let me say, I just appreciate, Kurt, you led and moderated the panel on the impact of AI on securities enforcement, regulation, compliance, and practice. And you started by including the audience, which I think took all of us aback. There were a couple of spit takes from folks in the back row when being asked to respond to some of your questions. I loved being able to see how many other folks in the room were considering those same issues, or we're following along on some of the way the commission has talked about AI in the past few months.
Yeah, I mean, the point Chris is getting at is I sort of asked the audience, like, how many of you have been involved or are currently involved in an SEC investigation that has something to do with AI, right? Because we hear a lot about it. Chair Gensler talks a lot about it. Former Director Graywall has talked a lot about it, and it seems to be an important part of the SEC's enforcement agenda, except they just don't bring a lot of cases, right? And that was one of the things that I hope came through on the panel. There really have been only a handful. I think there have been 3 cases against registered investment advisors, 2 cases against public companies that all have something to do with things those entities have said publicly or disclosed about their use of AI. There was another case called Kubient that we brought up and talked a little bit about on the panel, which interestingly was not touted as an AI case, but has an awful lot to do with the way that this company says it was using AI. I think one of my takeaways from my meetings with my panel, who were fabulous, by the way, we had Arlo Devlin Brown from Covington and Burling, Brian Kowalski from Latham, Pam Parizek from Kroll, and David Woodcock from Gibson Dunn, fantastic practitioners all, was that, look, these feel a lot like they could just be disclosure cases, right? Like maybe they aren't a new style of case just because the thing that is being disclosed or not disclosed accurately happens to relate to AI. But it's been all of this sort of negative talk about how companies may be getting it wrong. And what my panelists wanted to talk a lot about was how companies can use AI to get things right.
Right.
And so I think instead of people steering away from AI or wanting to be late adopters, it was like, can I use this as a tool to monitor other public companies' disclosures to see how they're talking about certain things? Can I use this as part of a compliance tool to see what's happening in my own shop? Can I use this? There's a suite of tools that you could use for purposes of conducting a more efficient internal investigation. So while there certainly are challenges, and it continues to be something that SEC enforcement is focusing on, there are certainly opportunities as well to use AI to help whatever you're doing in your organization.
Yeah, I was happy to hear we just kind of move away from, what I call the con man theory of AI, just like ESG, just like crypto, just like the Brooklyn Bridge. There will always be people out there looking at the newest, area of interest from a market's perspective and saying, I've got the best AI, give me your money. And then they go and buy themselves Lamborghinis and real estate and never have an AI anything, right? So I'm glad we moved away from that discussion because, again, that's going to keep happening with whatever comes after AI. But being able to think about the ways that artificial intelligence can be utilized not only to better mind your P's and Q's internally, but maybe even help support some of those discussions with the commission about how you're running your practice or about how your broker-dealer operates can be really useful, I think, in those coming conversations.
Yep, absolutely. Absolutely. Okay, I think that's everything we wanted to cover for the Securities Enforcement Forum 2024. I will just note for anyone who's tuning in and thinks, that sounds like a good conference, the next edition of the Securities Enforcement Forum will actually take place in New York City for the first time. It was in DC for a very long time. They added the West Coast a couple of years ago, Chicago, but it's coming to New York for the first time on January 28, 2025. It will be at the JW Marriott Essex House, New York. Again, I think that's going to be a really timely and interesting forum, just about a week, 8 days or so after President Trump is inaugurated. So there will be much to talk about in terms of who is the new acting chair, what do we think that person is going to be doing at the SEC, and what does that mean for SEC enforcement?
And for those of you looking for more information on the suite of Securities Enforcement Forum programs, you can check that out at securitiesdocket.com. Also check them out on social media, Securities capital D, a wonderful presence by our good friend Bruce Carden. And again, just another great event and a great excuse to hang out with you, Kurt, for a few minutes.
Ditto, buddy. I always enjoy seeing you there. And even got to have a breakfast with you this year. So it was like a bonus hang.
We made it work. Thanks for joining us for this episode of the inSecurities podcast. We always love to hear from you, our listeners. Look for us on social media to share your thoughts and comments or topics you'd like for us to explore on future episodes of inSecurities. Please use the hashtag inSecuritiesPod on X or LinkedIn to join the conversation. You can find me at EcomoffCPA.
And I'm at enforce_update.
Don't forget to subscribe, rate, and review inSecurities wherever you listen. Be well, everyone, and we'll see you next time.
Thanks for tuning in.
Thanks for listening to inSecurities, a podcast from PLI, the Practicing Law Institute. PLI is a nonprofit provider of authoritative professional services training and continuing education. In an increasingly complex business environment where intricate corporate structures reign, inSecurities can help you make sense of it all. A special thanks goes to the producer of inSecurities, Daniel Peinitz, as well as hosts Chris Ecomoff and Kurt Wolf. For more information about PLI's SEC Institute, or to view hundreds of hours of fresh and relevant on-demand programming covering changes within the security sector, visit pli.edu/membership and sign up for a privileged membership. These recorded materials are designed for educational purposes only. This podcast does not constitute legal, audit, tax, consulting, business, financial, investment, or other professional advice, and it does not create an attorney-client relationship. Please consult a qualified professional advisor before taking any action based on the information herein. Furthermore, the views and opinions expressed in this podcast are solely those of the individual participants. These views are not the views of the hosts or their employers. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission from PLI.